Welcome. My name is Nahom Gabriel, and I'm a risk management attorney at Victor O. Schinnerer. One of my roles here at Schinnerer is to review contracts on behalf of our clients for insurability purposes. I also serve as liaison with the Engineers Joint Contract Documents Program, and I'm fairly familiar with the AIA contract documents as well. In my prior life, I was in-house counsel to a large engineering firm where I had to negotiate contract clauses with clients, and I think today's topic would be very interesting for design firms that are routinely engaged in negotiating with clients. So let's get some of the housekeeping activities out of the way first. Be aware that if you are an architect, you can receive 1 hour of health, safety, welfare learning unit for this program. You'll have to respond to a follow-up email from the webinar system. Similarly, engineers and others who self-report continuing education can obtain a certificate of completion. And these are some of the details as far as the AIA system that this course is registered with. Let's get started. At the end of this course, what I want you all to get out of this is that you need to understand what the business and professional risks are by onerous contract documents that you get from your clients. In the last 2 webinars that we did, Frank discussed in detail the updated versions of the AIA documents and presented some of the changes that have been passed on in the 2017 AIA documents. Similarly, EJCDC will soon start the revision process for the E500 documents, and those are great documents if you can get to use them. However, a lot of times your clients have their own drafted agreements that they insist that you use, and you as design professionals need to be able to understand what the clients are asking of you and be able to effectively negotiate so that the terms are more reasonable. This requires practice on your part. It requires that you understand the risks that are presented to you in these agreements and to be able to confidently speak to what your clients are asking of you. It does you no good to be compliant when it comes to client demands, especially if you're not understanding what the terms are. So in this presentation, we'll seek to identify some of those onerous provisions. We'll contrast them with the sample language that we see in the AIA and EJCDC documents and identify what the differences are and how you'd be best served by being able to provide alternatives to your client. Here at Schinnerer, we review contracts for our clients over the year, and we review them for insurability purposes, and we review about 1,500 contracts in a year or so, and we see a lot of different clauses. All of the client drafted clauses that you see in this presentation are things that we've pulled out of documents that our insureds have given to us that come from client drafted provisions. This is not a work of fiction. These are actual clauses that we've seen in these agreements, and it's important that you, as a design firm running a business, be able to respond to these terms and negotiate as best as you can. So that's what we are trying to accomplish in this webinar today. If at any time you have questions, I believe you'd be able to submit questions in the webinar. You can make use of that. I will try to address them as they come in. If we haven't had a chance to address any particular question, feel free to follow up with us, and I will try to address it as best I can. But this is an important topic that I hope will be of use to you. So, what are contracts? Well, contracts essentially are a means of assigning roles and responsibilities between 2 or more parties who are entering into an agreement. Remember that it does not have to be in writing for 2 people to enter into an agreement. You can have an oral contract. However, we strongly urge all firms to enter into written agreements, mostly because you certainly want to make sure that your rights to payment for services are fairly clear and spelled out so that you know what your recourse is if your client decides not to pay you. This is an important feature because your contracts essentially are an agreement between you and your client to exchange items of value. You are promising your client to provide them with design services or professional services. Your client is promising to pay you for those services. That's, in essence, the bargain for exchange. And as far as the legal system is concerned, as long as both of you parties have come to an agreement and it is for a legally permissible purpose, this agreement will be enforced in a court of law if indeed you come to a dispute between you and your client. So this contract is essentially a way for you to be able to manage your business risks accordingly. Remember that in the event of a dispute, and forgive us for talking about disputes at such an early time in the webinar, but coming from an insurance company perspective, that is the world in which we live in most of the time. Most of your projects don't have problems. We understand that. Most of your problems end amicably between you and your client. Everybody's satisfied and they will walk away. But when they do not go as planned, the problems can be quite severe. Contracts are a way in which you can help manage the risk between you and your client. Remember that 2/3 of all claims in our program come from your clients. Similarly, the amount of money that is spent in our program in terms of indemnity, most of that goes to the client. It is not the third-party claim. It is not the contractors that we pay out to. For the most part, about 2/3 to 70% of all claim dollars in severity go to the client. So if you can manage this piece well, then you're well on your way to managing your practice well, to managing your business practice effectively. The last thing you want to happen during a claim is to find out that your written agreement that you took pains to negotiate with your client no longer reflects the current reality of where the project is at the end of the project. So if there are additional services that have been done, those need to be documented. They need to be, you need to amend your agreement to make sure that what is indeed the current state of your project is reflected in your agreement. This is also a way for you, the design firm, to manage your project, because anytime there's a change in additional services, which is not unusual in a design contract because there are additional conditions that show up, you want to make sure that that is an opportunity for you to collect additional fees. The last thing that you want to have is an agreement that you have taken pains to negotiate, and you come to find out that things have progressed beyond what is stated in the agreement, and there's no actual written, executed agreement in place that reflects the reality between the two entities. So to mitigate contract risk, you need to be able to determine who's in the best position to carry out each responsibility and assign that responsibility accordingly. Construction contracts are complex. There are multiple entities involved. In a design bid build environment, there's you, the design firm, and the owner, and you have a professional services agreement. There is also a separate agreement between the contractor and the owner, and that's the contractor-owner agreement. You want to be able to assign responsibilities in both of these agreements clearly so that everybody knows what they're supposed to do. We'll talk about construction phase responsibilities, for example. You want to make sure that it's clear that it is the contractor who's responsible for site safety issues, because generally in this relationship, you have no control over the site or the contractor, so you don't want to assume those kinds of responsibilities. Similarly, we talked broadly about what the responsibilities of the owner and the design professional are. The owner pays you money, you provide services, but the owner also has additional responsibilities to you. For example, they're often tasked with providing you with information on which, hopefully, it's established in your agreement that you have the right to rely on it. This is an important feature because as you write your scope of services, you need to have that right to rely so that you can price your services accordingly. So all of these things should be coming into play as you talk about what your contract is going to look like with your client. When we talk about using language that creates realistic expectations, you need to be cognizant of who else is potentially going to be reviewing this agreement. As I said at the beginning, this agreement, in the event of a claim, will be reviewed by others if there's a dispute. First and foremost, your claims analyst from CNA will ask for a copy of an agreement if there's a problem, and look at what you and the client agreed to, and then make a determination on what actually happened. But beyond that, if there is indeed a dispute resolution phase, this agreement will be placed before a judge or an arbitrator, depending on what your dispute resolution mechanism is. So the language that you use in how you describe your services needs to be realistic. You want to make sure that it's objective, makes sense, and that both parties understand what it is that you're promising to provide to the client, especially when it comes to schedule obligations. A lot of times, especially with new projects, your role is to help the client put a capital asset into place. Well, the client may well have other concerns as well, like financing requirements, pulling the permit in a timely manner so that they can secure financing. Your services are essential for the client to get their objectives met. However, you are not in total control of how quickly these services can be completed. You're often relying on information provided to you by the owner. You're often relying on feedback from government authorities who need to review the drawings and be able to give the owner the required permits. So you certainly want to make sure that what you're promising the client in your agreement makes sense and is realistic, because otherwise that could put you and your firm at risk if there is a problem. So when you review contracts, how do you go about it? As I said, often here we review contracts. We see all kinds of agreements, from 5-page agreements to 200-page agreements with multiple amendments that one has to wade through to try and understand what the purpose is. But anytime you review language, what you want to think about is, well, what is the plain meaning of this language? Step back and think beyond the legal gobbledygook that you see. Would you be able to explain this provision in plain English? Oftentimes we get caught up in throwing around legal jargon without really understanding what the parties are trying to accomplish. And as architects and engineers, your obligation as you run your firm is to understand what these contracts really mean. And beyond understanding it, you need to be able to compare it to something else, something that is reasonable. And for us here, as we try to educate insureds on what these clauses mean, we often look to the E500, which is the Engineers Joint Contract Document Committee form agreement between the owner-engineer, or the AIA D101 from the AIA Documents Committee. These forms have been developed over the years to clearly identify what each party is supposed to do. And as folks who are running design firms and making business decisions, you need to be able to use these language or language that you have developed with your own attorney as options. Because if you can't compare it to something that is reasonable, you may look at a provision and think that's okay, but you need to be able to compare it to something that you know very well and be able to negotiate based on that. Ultimately, you need to make a determination whether they're reasonable, the provisions are reasonable, and consistent with available compensation. You are running a business, and as such, you want to make sure that the fees that you're charging are commensurate with the risk that you're taking and enough for you to make a profit. It is not in your interest to look at these proposals and contracts without bearing in mind that this is ultimately a commercial relationship between you and your client. You're trying to make money here, and you have to stay in business. And to that end, you have certain risks that you have planned for. Risk is something that you either actively manage or you can transfer. And contracts are certainly one way of transferring risk. That's why we're talking about it today. But insurance is also another means of transferring risk. And to that end, you all have purchased your professional liability policy. And each portion of your fees is going towards paying that premium. So you want to make sure whether your contract creates obligations that are uninsurable. If they do, what can you do? How do you negotiate with your client to make sure that these are indeed reasonable and you can get back to an insurable obligation? If after negotiating it's clear that you are not going to be able to get an insurable obligation, then you, the design firm, needs to make a business decision. And it's best that you understand what your obligations are before you decide to go on, if you decide to go on, so that you can at least, A, understand what additional risks there are, and B, make a determination as to whether your fees are reasonable to handle this potentially uninsurable exposure. That's a business decision. Your insurance company isn't saying that you need to refuse these clauses because they're uninsurable. That's not our role, and that's not our intent. We know that oftentimes you have to make a business decision, and as long as you know what you're doing and have made that judgment based on the information that's available to you, that's generally considered an acceptable business risk that is on you. So, as I said earlier, we review a lot of contracts, and the clause that I want to highlight in the next slide is something that came across our desks earlier this year. It's all good and well to say, well, what is the plain meaning of each provision? But sometimes you're really faced with a clause that doesn't make much sense. And here's an example of something that is really very difficult to get hold of. Take a look at this language. It is not easy to decipher. If you're struggling to understand what this means, don't worry. There's a lot of contract language out there that your clients use that were drafted in a bygone age, and it's difficult to parse through this. And there's no magic language to this. It takes time. You need to practice doing this. You need to be comfortable reviewing contracts. And you also need to understand that there is no such thing as a magic list of words that you need to watch out for. You need to read the language in the appropriate context in which it appears. So, we're sometimes asked, well, do you have a list of magic words we need to avoid? We don't, because we can come up with a list. We've seen enough of these things, like, don't use the words warrant or guarantee or so on. But really, it does depend on the context. You can warrant that you're a duly licensed architect in the state of Kansas, wherever you may be. That's fine. That is a verifiable fact, and as long as you maintain your licenses, the use of the word warrant in that context doesn't create an issue, because indeed you can make such a warranty statement. So it really does depend on the context. So, and in this case, it does refer to a clause 6.3. So obviously, it makes sense to review what clause 6.3 it talks about and try to understand what the context is. But when I used to negotiate with clients, and it was obvious to me that the clause itself didn't make much sense, or there was just something in their standard form, I would actually call up and say, hey, you know what, I'm having trouble understanding this. What are you trying to say here? Because oftentimes, if you force the other person to determine what their language, what their form of agreement says, that's the basis of the conversation, the basis of negotiation. And if they're struggling, then maybe they're more amenable to amend that clause. So don't be afraid to call up the client and say, hey, I'm not quite sure what you mean by this clause here. Could you help me understand what you're trying to accomplish here? And use that to start the conversation. So as in most things in life, you get what you negotiate, not what you deserve. I'm not talking about your personal life here, but it is true. If you don't ask, if you don't know what you're looking for, you're not going to get what you deserve. So when you're talking to your client, be sure to be prepared, confident, and objective. Try to use objective terms as you look out for your interests, and try to define what your responsibilities are. A good resource, if you are interested in reading some more on negotiation, is a book called Getting to Yes, Negotiating Agreement Without Giving In. This was written almost 30 years ago. I believe it's been updated since. It's written by Roger Fisher and William Ury, U-R-Y. And if you really want to delve deep into some principled negotiation tactics, that would be a good resource for you all to look into. So what is a wise agreement? It can be defined as one which meets the legitimate interests of each side to the extent possible. You need to be able to identify what the client's interests are so that you can effectively talk to them about what's important to you, identify what is driving that client, and try to think of solutions. Now, one thing that I've seen in the industry is that design professionals, both engineers and architects, are basically problem solvers. And you're always trying to look out for the problem, try to identify issues, and that's great. But when you're negotiating, remember that being nice is not necessarily the answer. You can be vulnerable to a hard bargainer if your mode is to be nice and try to resolve the issue. You need to really understand what is important to you and resolve the issue accordingly. Separate the people from the problem. You have two kinds of interests really when you're negotiating. You have an interest in the substance of the agreement, the current agreement, but you also want to make sure that you don't jeopardize your ongoing relationship with your client. Make sure that you understand that the relationship can become entangled with the problem that you're trying to solve. So deal directly with the issues that you're facing, but separate the people from the problem. This takes time. It takes practice. This is not something that is easily learned. But the more you get into it and more comfortable you are and you're more confident you are about what it is that you want, then you can start negotiating effectively. Prioritize your issues. Not everything that you identify in a contract is a deal breaker. It can't be. Otherwise, you won't stay in business for much longer. So you need to be able to prioritize your issues because the client also needs to be able to feel that you're negotiating effectively with them. Have options ready. And the purpose of this webinar really is to be able to give you some options about how to resolve these contract clauses that you're running into. If you have options, if you can provide solutions, then you can engage in a conversation and be able to work things out with your client, ideally. And then finally, don't exchange fees for silver bullet contract provisions. The risks that you have as a design firm providing services are yours. And really, regardless of what's going on in your agreement, some risks will be yours. As a design professional providing services, you will be always tagged with responsibility for that project. So do not get caught in a trap of saying, well, if you give me this provision, I will take money off of my fees in recognition of that. That is really not the way to run a principal negotiation with your client. Instead, work towards identifying what the client's issues are, what your concerns are, have a principled discussion with the client, and then work accordingly to come to an agreement. So that's the intent of what you're trying to accomplish as you negotiate with your client. All right. So in brief, we could talk forever about negotiation strategies, but we have a limited amount of time. So let's discuss now our risk-intensive contract clauses that we often run into. Again, these are the 6 issues that I thought I would cover. And then briefly at the end, I will talk about limitation of liability provisions that some firms insert and what the options are for you all. So we'll talk about standard of care, that's your performance standard, code compliance requirements, opinions of cost, compensation, indemnification, and construction phase services. And in the next section, what I'll do is I will look at a client-drafted provision, see what are the problems, identify what these are, and then talk about what the alternatives are to address these issues. So let's start with this type of performance standard. The consultant services shall be performed in accordance with the highest standards of the profession and for the sole and exclusive benefit of the owner. The reason this is not appropriate is that it implies, number one, that there is such a thing as the highest standards of the profession. You're all doing phenomenal work providing services to your clients, but given the fact that you have a scope that's described and limited money, the key is to realize that something as subjective as the highest standards of the profession is very difficult to establish if this thing should ever be litigated. It's almost impossible to verify what indeed the highest standards of your profession are. Also, it implies, in my opinion at least, a fiduciary obligation of sorts, which when you say things like the sole and exclusive benefit of the owner, it implies that you are expected to look out for the interests of the owner at the expense of everything else. Your typical relationship between a design professional and a client is one that is at arm's length. You are in a commercial relationship established in your written agreement, and there is not an expectation that ordinarily that you are looking out solely for the interests of the owner. Also, remember that as licensed professionals, you're expected to protect the health, safety, and welfare of the public as you're performing services. And a clause such as this could indeed be seen as jeopardizing your obligation under your license. So keep that in mind as you negotiate with your clients. So as you think about your performance standards, let's look at how the AIA 101 responds. And this is a fairly typical phrase that you will see in all the standard form agreements This is what you want to aspire to, right? You want to say that you're going to be providing services ordinarily used by members of the subject profession practicing under similar circumstances at the same time in the same locality. You are essentially expected to perform services in the same way that another engineer or architect or surveyor would have at the same time and under the same circumstances. You want to avoid warranty obligations, something that promises the client a particular outcome or result, because that opens you up to a breach of warranty claim, which is a lot easier, number one, for the client to establish, and number two, does not reference the standard of care that is expected of you. Your professional liability policy is written to provide you coverage for the exposure that you have for negligence in the performance of services. So to the extent possible, you want your contractual obligation to replicate that. One more thing that I want to say about the standard of care is that if you have schedule obligations, time is often a critical element for your client. They want certain milestones met. They want to make sure that they are meeting their obligations to their lender, to whoever is involved with the project. So that is oftentimes trickles down to the design professional. And that is an important element, and it should be addressed in your project. However, you always want to make sure that these obligations are tied to your standard of care and that you will perform these services as expeditiously as is consistent with such professional skill and care and the orderly progress of the project. A statement like that oftentimes helps clarify what is expected of you. And as long as you tie it back to that standard of care, then you're in good shape, at least as your contractual obligations are concerned. The other thing, in terms of practice management that I want to point out at this point is that it's important that you and whoever's managing or running your project understand that your contractual obligations are indeed what sets up the relationship between you and your client. It's great to have a well-written, executed agreement in place, but if by your actions you have taken on additional responsibilities, then you really have lost the protection of what you've taken so much time to negotiate. So it's not just about negotiating and executing reasonable agreements. It also is important that your conduct during the project itself reflects what is prudent and that you stick to the agreement. If there are changes, then make sure that those changes are reflected in the agreement, and hopefully you're getting additional fees for those changes as well. All right, let's move on to code compliance issues. Again, the client has concerns about code compliance that they're trying to pass on to you. And here's an example of a client drafted clause in regards to code compliance. Consultants shall design the project so that when constructed, it will comply with all codes, laws, regulations, standards, and all other requirements and interpretations, including any changes made or anticipated prior to the final completion of the project. Well, obviously, this is too broad a statement for which a reasonable design firm to agree to. You're being asked to guarantee that when this thing is completed, and an item that is typically not within your responsibility, but the contractor, that it will comply with all the codes, regulations, and standards that are out there. This is impossible for you to guarantee under a normal set of scope of service agreements, because code compliance is dependent on what? The contractor's adherence to your plans, number one. Number two, it also depends on how the owner is operating the facility and whether it is indeed being done in a manner that meets the expectations that they set out at the beginning of the project. And furthermore, in the if a code changes, or importantly, the interpretation of a particular code changes after you've executed an agreement, that risk should rightfully fall on the owner and not on you, because your scope of services does not envision that, and it's not a reasonable risk. So how would you handle this? Well, you certainly want to assure the client that you will comply with applicable laws and regulations and owner-mandated standards that have been provided to you. So your client may well indeed have a preference about what kind of sidewalks they want on their campus, what the landscape requirements are, and they may well have detailed guidance about what they want to see on their project. And it's certainly reasonable for you to ask for that in writing, clarify it, and then say, yes, we will indeed make sure that we incorporate this in our design. After, however, the effective date of the contract, then it should be clear that changes that relate to these types of things are indeed a basis for contract modification. So these are the types of things that you need to think about. You know, it may seem quite a simple request to have it in a contract, but it could actually open you up to a lot of grief if indeed this type of clause is in your agreement. So let's briefly look at how the EJCDC responds. It does recognize what the owner's instructions are, but it also importantly says that your obligation is subject to that standard of care that you've taken the time to identify, hopefully somewhere in your agreement. And it also recognizes that these are, the compliance should not be inconsistent with professional practice requirements. This is enough of reference to the standard of care, what is ordinarily expected of you, that it's reasonable. It addresses the owner's concerns, but at the same time, it does not put you at risk. So you need to think about how to address this with the owner. Opinions of cost. Again, as you're helping the client put that capital asset into place, the client is definitely concerned about how you're going to, how much this is going to cost, and on who's going to take responsibility if it should exceed their budget. Well, let's look at this clause, for example. Consultant acknowledges and agrees that should the lowest responsive bid exceed owner's budget as provided herein, consultant shall be liable to owner for any and all additional direct and indirect costs occasioned thereby. Now, I didn't come up with these clauses just because I have a creative bent and put myself in the shoes of an owner. This is actually something that a client presented to one of our firms. And language such as this puts a lot of risk on you. Number one, you don't know what current market conditions are. So the lowest responsive bid could very easily exceed the owner's budget. If you are indeed providing cost estimates, a lot of times those are conceptual. You're going off of, you know, this is how many linear feet of pipe we're putting in. We think this is how much it costs per foot, and you know, you do a quantity takeoff, and based on that, you kind of give a conceptual cost estimate. That is not how the marketplace operates. There could be any number of things that affect how the bid is going to come in. Furthermore, the owner's budget, you know, is really the owner's budget. It may not have anything to do with current marketplace realities. And especially if they don't have contingencies in place, there's going to be a lot of surprises oftentimes during construction. So your responsibility normally is to be responsible for damages due to your negligence in the performance of services. The direct and indirect costs occasioned thereby has no tie to your negligence. This is solely a business risk that the owner has and should stay with the owner because they're the one benefiting from the facility. So for all of these reasons, I'm outlining what it is that you want to convey to the client when you're faced with these onerous clauses from your client that you need to discuss with your client and come up with options. Your opinions are based on your experience, qualifications, and your best judgment at the time. You have no control over the cost of labor, material, equipment, or contractors' methods, and you can't make guarantees. And, one of your arguments is that, hey, you know what, my insurance company tells me that guarantees are not covered. They're a business risk. And, you can certainly blame the insurance company as you negotiate with your client. So here's the language that you see in E500. They use the term probable construction cost based on your experience, qualifications, and general familiarity with the construction industry. And so you can review the clause and see where you want to be in terms of defining what your role is. If the client wants further assurance about what the cost is going to be, then you certainly want to direct them to a specialized consultant who can provide such services, or you can provide those services too if you feel like you're qualified to perform those services. That is certainly an acceptable route, but under the normal scope of services, you're not generally in a position to assure the client of certainty about what the construction cost is going to be. And of course, the next thing we're going to talk about is compensation. This is important. Remember, you're providing services for fee, for money. This is in essence, the relationship you have with your client. Now, I know you have relationships, ongoing business relationships that are meaningful and a lot of times go beyond money, but we're talking about the business of design, and we're running a business here, and let's keep that in mind as we negotiate with the client. Consultant's fee shall include all necessary services and shall be subject to withholding by owner if services are deemed to be unsatisfactory. Well, these things almost tell you what the problem is, right? Who decides whether something is satisfactory or unsatisfactory? There's no objective criteria here to determine what is indeed satisfactory or unsatisfactory. Furthermore, it's all at the discretion of the owner, and things change during a project. So if there's additional services that are required, your fee should ultimately be adjusted accordingly and your scope amended accordingly to take that into account. So don't forget the additional services that may be required during the course of a project. If you handle that well and you manage the scope creep process that's almost inevitable in a lot of projects, but if you make sure that it is addressed, then if there's additional responsibility you're taking on, that it matches up with the fees, then that's certainly an excellent way to handle the risk. So be very clear about your payment amount, what is required, and what your rights are if the client decides not to pay you. Beyond just the compensation amount, you need to make sure that you tie in what the remedies are if the client suspends payment or stops paying you. What are your rights? Do you get to suspend your services upon notice? Do you get to eventually terminate the services? And so what is your recourse to protect your rights? That goes just beyond the compensation. And in the interest of time, we can't get into that right now, but be aware that it goes beyond just identifying what your compensation is. You also need to think about what your rights are if the client decides not to pay you. Okay. Of course, indemnity. What webinar on contracts would be complete without a discussion of indemnity clauses? Consultants shall defend, indemnify, and hold harmless clients, officers, and so on, whether alleged or actually caused in whole or in part by consultant's design, breach of this agreement, willful action or misconduct, or any other actionable fault. Pretty much with an indemnity obligation like this, almost anything can be alleged to relate to your design, your breach, or your action. Your indemnity obligation is actually not even triggered by your responsibility, but by, it looks like, an allegation. Furthermore, you have an upfront obligation to defend this cause, and for reasons stated earlier, these types of clauses create a challenge because they're not an insurable obligation, and they could further open you up to an indemnity obligation that is fairly broad and could essentially be uninsurable. So you want to look at an indemnity, propose an indemnity obligation based on comparative negligence. E500 does have an option to select a mutual indemnity clause so that you're providing an indemnity to the owner and the owner is also providing an indemnity to you. That at least leads the discussion towards making sure that the indemnity is reasonable on both parts if the client is willing to give you an indemnity of some sort. Remember that the indemnity is really, in this case, it is intended to apply to third-party claims, not to the owner. The owner, your obligation to rectify them for harm caused by your negligence is there, even if there's no indemnity obligation, it's implied. You are indeed expected to make them whole for your negligence. What we're trying to address here are third-party indemnity claims. And as we see in the following two slides, these are the suggestions that the EJCDC and the AIA documents have suggested as responding to your indemnity obligations. Generally, you want to make sure that it's triggered by your negligence. It is based on comparative negligence concept, and amend it as best as you can. Similarly, the AIA documents had a similar clause, not in the B101, but in the B103. And interestingly, the AIA has decided to couple this with a limitation of liability clause that that limits the indemnity obligation to available proceeds of the insurance coverage required by this agreement. Your client may well balk at agreeing to limiting your liability, but it's certainly worth an effort for some claims. One last thing I want to say about indemnity is that, you know, a lot of times what you're faced with is a broad defense and indemnity obligation from your client, and they're actually designed to respond to claims that would be covered by other insurance policies, such as the commercial general liability. That indeed does have defense rights to the owner if it's an insured contract. And so it's oftentimes difficult to negotiate because the client says, well, wait a minute, you have insurance. So one thing that I've seen increasingly over the past 4 or 5 years is clients willing to separate out your professional liability indemnity obligations and saying that, you know, with respect to claims insured only under the professional liability policy, it only applies to such claims that result from your negligence in the performance of professional services, and your defense obligation will be the reimbursement of your client's reasonable legal expenses in defending against an allegation of harm once that failure is determined. So again, this is an attempt by you to craft an alternative so that you're not facing a broad indemnity obligation that is intended to cover risks other than your professional liability. All right. The last clause that I wanted to cover is construction-based services. Here's the client-drafted clause. Consultants shall inspect the work whenever and wherever necessary to assure contractors' compliance with the contract documents and all applicable codes and standards and to protect owner from defects or deficiencies in the work. Again, this is really not the typical role of a design professional. And one of the great benefits, in my opinion, of the standard form agreement is that the role of the design professional during the construction phase is actually well defined in both your agreements and in the owner-contractor agreement. And so if you're lucky enough to use those agreements and they haven't been amended, then you know that there's coordination. Your goal is to represent the owner interest, but ultimately responsibility for the construction should lie solely with the contractor. A clause such as this allows the owner to make a claim directly against you because it imposes responsibilities on you that go beyond what is typically expected of a design professional. So it really comes down to what your scope of services is going to be during the construction phase. If you are going to provide detailed construction phase services where you have a resident project representative on site, that's fine. Let's base it off of the scope of services and outline what is expected. But at the same time, you want to make sure that responsibility for site safety and construction means methods resides solely with the contractor. And to that end, you want to say something similar to what's stated in the AIA document B101. You will not have control over, charge of, or responsibility for the construction means, methods, techniques, or for safety precautions and programs in connection with the work. When you face a client drafted provision saying that you assume responsibility for the safety of your employees, the safety of others, or the safety of the public, and keeping the site safe, be very wary, because you typically do not have enough control over the site or the property to be able to assume that kind of responsibility, because you're there on site to do oftentimes a limited observation and take note of what's going on and leave. You don't want a broad responsibility about keeping others safe or the property safe, because that could easily be a way of dragging you into a claim. So the last thing I want to discuss today are limitation of liability provisions. Some firms are fond of these, and they try to insert them in a lot of their, in almost all of their agreements. And the intent here is to limit the liability of one party to another by contract. Essentially, you're attempting to share the professional liability risk. When these types of provisions are litigated, they're highly scrutinized by courts, generally speaking, because it does imply that the design professional is attempting to avoid responsibility due to their own mistakes or their own negligence. And that, from a public policy standpoint, the courts would look at whether that offends traditional notions that a party should indeed be responsible for their actions, especially a design professional who has been tasked with protecting public health, safety, and welfare. So there is that concern about enforceability. However, courts in the U.S. are also pretty big on freedom of contract. So if it's between the client and you, they certainly don't want to step into your ability to enter into a contract, especially considering that courts generally consider both you and the client fairly sophisticated entities that can handle their risk. But if this is of interest to a firm, there's several options in which you can pursue how to limit your liability. E500 has by far, in my opinion, the most comprehensive response to this, where you can limit your liability to the amount of the engineer's compensation, amount of available insurance proceeds. One thing that I like to see in an agreement is the exclusion of special, incidental, indirect, and consequential damages. Clients oftentimes are willing to accept those. So that could be an excellent way to limit your liability that the clients oftentimes accept, because there's a recognition that your scope of damages should be limited, hopefully, to the direct damages, as opposed to something that could be deemed consequential. So I think that's an excellent way of trying to limit your liability. So if you're looking at limitation of liability provisions and you put it in your standard form agreement, do not be surprised if your client comes back and says, hey, we want to delete this. That should not be an element of surprise to you. You want to be able to come up with options, see what makes sense, and whether or not you're willing to proceed with a different type of limitation of liability or not. So that really is a business decision. Whether or not you choose the limitation of liability provision, that's solely your decision. You know, the CNA Schinnerer program does not require that you put these in your agreements in any way. Those are business decisions. But we do know that in the event of a claim, having a limitation of liability provision in a jurisdiction where you know, that is likely to be where it is likely to be considered enforceable does help your bargaining position. So just keep that in mind. But it's up to you in your various jurisdictions to determine what is indeed likely to be enforceable and consult with an attorney about what makes sense, and also be aware of any recent developments about enforceability of these types of provisions in your particular jurisdiction. So one thing I want to point out to you is if you're in a sub relationship with another design professional, oftentimes you have got to review the prime agreement, because your agreement with your prime says that the terms of the prime agreement are incorporated. So, you know, you're not likely, if you're in a sub, to get better terms with your client than what the prime has gotten with the client. So as you negotiate with your contract, with your client, if it happens to be another design professional, oftentimes, you know, you're not likely to improve the situation much, because the prime is not likely to provide you with better terms than what they've been able to negotiate with their client. So just keep that in mind. And if you're a prime, be aware that you have the vicarious liability of all of your subs. And if the sub is indeed wanting to get special terms, then one option, if you decide not to assume responsibility, is to have the client deal directly with the sub and have a separate agreement, so that the client is responsible for providing you with the information that you need and that you can rely on, and you don't have that vicarious liability. So just briefly, that's pretty much all I have to say. If you have any questions, feel free to reach out to Andrea Tyler and let me know. I hope this has been helpful. Our next webinar is on October 11, and my colleague Frank Musica will be talking about intellectual property. Protect yourself and your compensation. And it really is important that you address what your intellectual property rights are in the instruments of service that you produce. And Frank will be putting on that program in October. Following that, in November, we have 5 legal cases every design professional should know. So please make sure that you take the opportunity to sign up on our website and take advantage of these webinars that we're providing to you. I appreciate your attention. And again, if you have any questions about this topic, feel free to reach out to us and we will try to address it as best as we can. Thank you. This concludes our webinar.